Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, a Senator Godfrey, the fifth Caravan Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Typical English Church of England is no other than Jesus Christ, the King of Peace. It is February the 11th, 2024, which is the Berber year 2974. I'm here with another marvelous lecture for my subjects, my heirs, my successors, to our illustrious state that was left in dormancy, but now it has come from under the veil as a result of the illustrious teachings that has been preserved. Because as we said, as the scripture said, Jesus didn't come to change the law, but to fulfill the law. Okay, very important. He didn't say he come to fulfill the scriptures. He said he come to fulfill the law. All right. And the law is dealing with whatever law you're subject to. Land, air, water. All right. Most of the treaties that people concern themselves with the laws or the provisions that established for people based off treaties. All right. Based off treaties. But you have to ask yourself, what was those treaties concerning? All right. Was it concerning activity on the land, activity on the water, or activity in the air? All right. We know it wasn't in the air because they didn't have planes back then. And we know that if you were a spook, then this conversation wouldn't even be, we wouldn't be having this conversation. So the only two left is that of what we call admiralty law and that of what we call the law of the land or supreme law of the land. Okay. And supreme law of the land is determined by many fashions. Okay. Because we know a constitution, although we call it a charter, is a charter of limitations. All right. We first must understand that treaties that are made in regards to the parties involved is nothing more than a contractual agreement. It has nothing to do with the government. All right. They're made off some private or public agreement concerning some activity concerning the parties. Okay. So we must understand that. All right. Most of these activities do come up and fall up under the jurisdiction of the law. Okay, we also must understand that. All right, so you need to be careful of how you participate in society. All right, because we know that religious society has an autonomy, as well as when you say religious society, I'm talking about churches, temples, groups, etc. All right, you have some type of religious or spiritual autonomy, but you're still subject to the secular courts if it infringes upon somebody else. All right, in lieu of what we call the First Amendment violations. All right, but if your conversation uh, affiliated with these groups, uh, if you don't do an investigation, a sound investigation of the groups that you're listening to, then you're going to be in a world of trouble because a lot of people, whether you know or not, is watching my channel. Okay, they're watching our channel. All right, they're trying to use the language of the English people, which is no more than the English common law, which is the language of the English Anglo-Saxon burghers. Okay, you might speak the language, but that don't mean you have anything to do with the nation of people, because we understand the citizenship here in North America on a national scale or international scale, naturalized or national. It all means the same in the eyes of the colonization. They are not nationals. All right, nationals to them are naturalization because they're not really uh, 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 tied to the land by any genealogy, ethnicity, or geography. All right, nor any other person that does not fall under the government. All right, so we must understand the First Amendment as presented by Thomas Jefferson to the first governmental structure here in North America based off the colonization with the Virginia Assembly for the separation of church and state. And under the first separation of church and state, you come up under the autonomy doctrine of religious society that has nothing to do with a government. It has to do with ecclesiastical government. So when you deal with religious societies under ecclesiastical law, you're protected by the law. It has nothing to do with the secular courts or the secular government. All right, they got their own set of laws. In England, the secular and the or what we call the civil courts and the spiritual courts, i.e., temporal and spiritual, were connected. It was a fusion of power. We call that the King's Bench and King's Parliament. All right. So we must understand that falls under what we call the common law of England, only for the English people. People call their laws common law, but it's not our common law. Okay. So you cannot use the common law of England if you're not an English person. If you try it, you're going to find yourself in a world of trouble, especially when it comes with the property that belongs to the crown, which is a trustee for the English people in lieu of their estate that has been exceeded. All right. And I'm going to show you the examples of those who are cause our estate to go interstate and exceed to the not just the government, but as well as to them, because they claim to be acting as trustees on behalf of the use of the trust that was left for the beneficiary. I'm gonna give you an example, Brother Truth. I've been waiting to get on him for a minute. This brother got ID cards and everything, but don't have a clue about English history. Okay? Don't have a clue about it. And this is for all my heirs and subjects. I know we are having a struggle right now, but I don't want you to fall into any trap that I have not gone through myself. All right. So remedy is on the way, but I first have to test the waters. All right. Not like these other people who have provided you with presumptuous remedies where they're nowhere to be found when that presumption is tested. Okay. Such as Brother Truth, because this man claims to be dealing with estates. What type of estate we're talking about is yet to be known. But if any estate is to be assumed, it's probably dealing with what we call uh, 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 fiat money, because you can't be dealing with property. All right, you can't be dealing with property. My screen keeps freezing. You can't be dealing with property. So without further ado, I'm gonna address all of that. I'm gonna show you how your connection to who you are as a people identified by your complexion now don't have to resolve to that. You have a remedy in protection in lieu of the nationality, ethnicity, and genealogy that happens to be of this complexion. All right. Frederick Douglass recognized that, and he was at the time of this indentured servitude that we are still subject to do, subject to today. All right. As a result of the unconscious of who you are. All right. As English people, because the census number the English people and Black people pretty much the same percentage. All right. Outside of every other uh, people who are migrated here to North America. Okay, so I'm going to show you the validity and the facts and the evidence to support everything that I'm going to reveal to you. And this is a warning to all those who claim to be Jesus, who claim to be the one to restore the law. Okay, i.e., the common law of the people. All right. So, Brother Truth, I'm coming for you. My birthday is, well, play the video. All right, let's play the video. This brother don't have a clue. He gonna find himself in a world of trouble as well. All right. All those who follow this brother, you can just tell by his language. Look at this. Look at his dress code. You know what I'm saying? This is not the the standards or the prerogatives or the initiatives of a leader. Okay, not at all. All right. We don't see it in his appearance. Let's see if we see it in his language. All right. Brother Truth, live talk, I self law, know your rights. So apparently he must know law. He must know law if he's talking about rights. All right. He apparently must know law. All right. So let's see what type of law he's making reference to. Listen, y'all.
Peace and love, family. It's your boy, Brother Truth, man. And today, just want to come holler at you all. Definitely spread us. Trying not to hold y'all too long. This here lately, I've been posting a lot of different things and information, and just expanding, beyond law. And I just want to kind of let you all know and prepare yourself.
Start from the beginning.
Peace and love, family. It's your boy, Brother Truth, man. And today, just want to come holler at you all and definitely spread information and just really get a chance to just talk to the people whenever I can, man. I'm not gonna hold y'all too long. This here lately, I've been posting a lot of different things and information, and just expanding, beyond law. And I just want to kind of let you all know and prepare yourself for, the tour that's coming here in January, or the show that's coming here in January, the conference out there in New York on January 13th. That actually my birthday too as well. So I expect to see everybody.
That's funny.
At that joint,
my birthday is January 14th too.
I just wanted to kind of come in and touch on, because a lot of people, some people are like, oh, well, you should just stick with the law. You should only teach us that. And, I feel as if consciousness, stretches far, far, far beyond, just, knowing the law and the Constitution and equity and all these other kind of things, man. For me, it's about actually knowing, what's going on in your environment, being conscious to your history and everything else like that. Peace to the gods, good brother. And I say that just because, for me, it seems kind of hard to think that, we could know where we're going and how to actually execute and get there when we don't know who we are and where we come from in the past. So, for this very reason is why, I've taken years and, I've gone through the Aboriginal history, which I've gone through, English versus Roman military law, which we've gone through, Hebrew shit. We've gone through war shit. We've gone through all of these different levels and channels, because I like to say, in order to be a Neo or a God in this game, you're going to have to learn all of the different avenues of law. You're going to have to learn all the different avenues of heritage, your culture, and everything like that. Because especially as melanated people, we have so many divisions that were put on us, going all the way back, starting back in Yakub's time. This is why I even gave you the story of Yakub and understanding the reason why.
Not one receipt being presented at all. Not one receipt, y'all.
Certain things like religion was created in these 6,000-year cycles. Why so many wars? Why so many things have been happening and going on, bringing, I guess, can you say, detriment to this world, is because it had to happen, right? And as I always say, we had to learn and experience all aspects of God, right? And has not religion and wars and things of that not shown us the good and the evil, right? So it's just important that, because a lot of times, a lot of us are caught up in the Roman military law of things, and we actually think these codes and these statutes is the true way of life, as if this is what law is and what it was always supposed to be, not understanding that most people have a whole constitution that's here for them to operate and live by. But if you never knew what you...
Okay. He never said what that constitution is. All right. This is the question that y'all should be asking. Well, what constitution, Brother Truth, you talking about? All right. Because first of all, I don't know who you is. You calling your name Brother Truth. That's not the name of a people, Brother Truth. So first of all, that's a lie. All right. You're lying about who you are, because we don't know who you are. We just know you by the name Brother Truth.
Come from in the past, you can never know where you're going to go here in the future, right? So I mean, it's important that we teach all aspects of law, and we go back to understanding why even some of these legal systems and law systems were even put to place, going all the way back to Pope Boniface VIII, okay? Right? And that was in the 1300s where Pope Boniface VIII said, hey, we're going to make every single living being on the planet, right, a subject and a creature of the Roman pontiff. And ever since the 1300s, they've been doing it.
So he's in the 1300s. He forgot all about the conversion of the Anglo-Saxons in 597. He all the way up in the 1300s, all right? And applying the 1300 Rome laws of the pontifex to what's happening over here in North America. You know what I'm saying? So you haven't gone back far enough to even make some type of connection to the common law of England, where you say that you're an expert in, all right? When you say common law of England, you talk about Anglo-Saxon law or Anglo-American law. All right. I'm going to show y'all proof today. I'm going to give you case law. All right. To show you that if you're looking at from an abstract or concrete, you still got to come this way. All right. You still got to come this way.
Executing exactly that. Okay. So we need to understand that English common law was in place even before a lot of these Roman military laws. But
did you hear that? He said English common law was already in place before a lot of those Roman military laws. All right? But you going back to the 13th century. Why not take the people back to the time when it actually happened? Because you don't know that. That lets me know you watching my channel. But your mind is so slow that you can't catch up quick enough. All right? But hell, if your mind's slow, then imagine the minds of the people who listen to you. That means their mind ain't even working at all.
Again, after Englishmen and had went off across the world and set up these colonies and set up lands and set up different things like that, integrating with other indigenous people from other lands, right? You had Britain, who had finally came and took over the UK.
Hold on. Britain took over the UK. How the hell could Britain take over the UK when the UK was not created till after Britain? All right, and he gonna realize he made a mistake. Check him out.
You know what I'm saying? Well, Britain had came and took over England, then they took Ireland, and they
hold on. So Britain took over England. England and Britain is the same thing. I mean, come on, y'all. Y'all gotta find a better excuse for the mistakes that y'all making. All right? Because this man is no lawyer, and this is what Jesus warned you about. This is what the scriptures warned you about. All right? And the scriptures come from Anglo-Saxon origin. Yes, it does. I'm going to prove it. Case law going to tell you. All right? So it don't belong to you, Brother Truth. It don't belong to the Moors. It don't belong to the Israelites. It belongs to the Anglo-Saxon. It don't belong to the Hebrews. It belongs to the Anglo-Saxon. All these other stories and abstract allusions or assertions are a result of misinterpretation. All right? Let's finish. We're gonna let them finish out.
They took Scotland and they put all of them together and made the United Kingdom, and they said, we're going to call this Britain, and we're going to use this Britain entity to now go back and take over all of these English colonies over the world, these English lands, and we're going to start, implementing Roman military law. So when I showed you all that passport in my last post, and it says, that these passports apply to citizens and they also apply to nationals. It's important to know again that this is a dual legal system, okay? And it's been a dual legal system your entire life, all of us, okay? And at the end of the day, citizenship, as far as U.S. citizen, operates and falls under Roman military law, right? And they have certain codes, they have certain statutes, they have different things like that that are put in place to whoop your ass. I don't care if you live here in America. I don't care if you live there in South Africa, Canada, wherever the hell. I can promise you most 99% of you all in the countries that you come from are operating under a constitution. Facts, okay? And they're also operating under Roman military law. So really, truly, the real question is, which one do you serve, right? Because at the end of the day, I could talk private law, I could talk about Aboriginal law, I could talk about all of these type of things all day, right? We could talk about what we want to be in a private, we want to be a Moor, be a Hebrew, and all that. That's cool, but there is a game. a public game that's operating that you all have been participating in 99% of your life. And it's about knowing how to play that game, which is English common law versus Roman military law.
Okay, first of all, this is not a game for the English, third temple English church. This is not a game for us. This is a game for you, but it's not a game for the nationals. All right? So you got this twisted, brother. You're lucky I wasn't at that conference in January, because, bro, I would have been on you. All right? And you're lucky I ain't where you at, because I will be there now. All right? You are, matter of fact, I'm not going to tell you who you are. I'm going to let the scriptures tell you who you are. Okay? Let me let this finish out. Because I just came to fulfill the law. All right? I didn't come to change the law. I come to fulfill the law. And the law tells you who you are.
All right? Huge. Okay? So, I mean, before we even get into all that, I just wanted to kind of let that be known and put that out there on the table, because that's highly important. I think a lot of people kind of overlook, just the basics of English common law and Roman military law to kind of implement their feelings and emotions and opinions, but they don't give a shit about your feelings, right? They don't care. All they are executing is law, all right? So again, knowing where we come from, and this is why I break down our English heritage so much, and I say, yo, you must go and find out your English surname heritage too. Your surname, all of that. Some of you all are from Spain. Some of you all have surnames from England. Some of you all have surnames from Scotland. All of these type of things, man. And what do you think these Masons and all of this stuff get some of these Scottish rights and all of these other kind of things? This is actually part of your heritage too as well, okay? It's very, very, very important. It says with the U.S. national, we don't have a lot. We don't have a lot of filed taxes, correct? We don't have to file taxes, correct? You never had to file taxes, right? As any national, you never had to file taxes. Taxes are for citizens who are taxable entities operate.
Well, then who are you? Because the national is a naturalized citizen here in North America. All right? So if you're over here in North America, doing business in North America, you got to pay taxes. All right? It's just a matter of time, either on the state level or federal level. You have to pay some type of indebtedness to the state. All right? Whether you're going to the grocery store, whether you're going to a clothing store, whatever it is, you in some type of indebtedness. You're not a creditor. All right? The only creditors was the crown. And you, my brother, is not the crown. I represent the crown. I haven't paid taxes in over 15, 20 years. All right? Federal state taxes over 15, 20 years. Of course, I'm subject to the other encumbrances as a result of trying to establish that injunction on the state and federal level so that our English people will not be subject to these encumbrances that you're making them subject to as a result of your teachings. You haven't examined or gone through the rough and hard places in regards to be able to redeem the people, all right? Because if it was, you would be telling us now, all right? I'm telling the people, I'm revealing it to them, but I'm not going to tell them to go exercise that stuff on your own stuff. I'm going to do it myself. I'm going to sacrifice myself so that the people can have a clear path in the way they need to go. Because you know what? When they come down that path, who they going to see? They're going to see me standing there. You ain't going to be nowhere in the picture. Nowhere.
Under the Roman military government, right? You have the United States, Inc., right? And then you have the United States of America. U.S. citizens apply to U.S. Inc., right? And they are taxable entities, right? And they get taxed. And they work hard to pay off bills and shit that was already paid off, right? Those are taxable entities, okay? But when you are operating as a national, okay, taxes are actually unlawful. It's very important. And, even going all the way back to the Tea Party and all this other kind of things, people used to revolt over taxes. And what a lot of people don't know, that really wasn't even T, that was him. But that was another conversation.
Now he's saying this, come on,
another bill session. But yeah, man, I just want to tell everybody it's extremely important to know where you come from, to know where we're going here in the future. Even with the trees and all of the things that we've just been discussing too about all of these mountains out here that are really trees that have been cut down. It's important that we know that too. I teach that just because, we have to understand that the world and the environment that we live in is not the illusion that we really think it is. You know what I'm saying? Right? There was so many things beyond our imagination that used to exist in the past. We were so much more advanced. We were so much more technical, whatever.
Get it right, brother.
Back in the day, we were so much more everything, right? Back in the day. And really, we need to learn how to get back to those times and start thinking and operating like those brothers and sisters used to, like your ancestors.
All right. So there you see it. You can see the brother is straight lying. Okay? He is straight lying. Let me just close this out. All right. Let's go here. Let's let the scriptures tell him who he is. Luke 11:45 through 52. All right. So this is to you, brother, truth, and all you other persons who claim to be expert in the law. All right. Because Jesus is head of the church. All right. So Jesus wasn't arguing with doctors of the church or doctors of the scriptures. He was arguing with doctors of the law. All right. And if he was arguing with doctors of the law, that means Jesus must have been in court. All right. He was in the courtroom arguing with those lawyers who are now judges who are now got you in the position that you're in as a result of you not knowing the law. Okay? You're not knowing the law. If you're not getting a one who's experiencing the law from the church, then that means, guess what? You got one of their lawyers. All right? Because church and state is separated, as Thomas Jefferson put it. All right? Separate of church and state. All right, so the First Amendment cannot infringe religious doctrine, don't apply with the states. On the federal level, ain't in the state level, but it does protect your religious freedom to believe whatever you want to believe in. So you can believe in the church before it was broken up, or you can believe in that which came after the church was broken up, and now you can believe in anything you want to believe in, such as this brother truth. All right? Such as this brother truth. All right? He claimed to have the name Brother Truth, expert in the law, but don't know law. Why? Because the law he practicing is a law that bar members learn, the law that corporations learn. It ain't the law of God concerning the souls. It's a law concerning those who don't have souls. All right? Because you got the Lord's House of Lords, and then you got the House of Commons. All right? We understand the government that was established in North America based off the black churches, which is the Southern black churches, which majority of the people are associated with, it not just having to go into church, but if you read that Bible and the interpretation of that Bible, how they want you to interpret it, then that means that to them that was their intermediate heaven, and if that was their heaven, and they incorporated indentured servitude with that Bible, how they interpret it, which in turn made you subject to servitude, which means that this was your hell. Okay? This was your hell. And that hell you was in under that law was not the common law of England. Because under Somerset versus Stuart, when you stepped foot in England, you was a free man. All right? We must understand. So let's read the warning that our King Edgar the Peaceful left. Okay? Yes, King James wrote the Bible, as you read in the King James Version, but that was a usurpation of what was written based off those who were ahead of the church, of the English church, which was no other than King Edgar the Peaceful, which I'm the reincarnation of today. All right. We're going to prove that in case law. I did it in my last lecture. I did, but if you haven't reviewed that one, please go back and review that, okay? Please. All right. What are the experts in the law? Let me make sure you all see that. This is scripture. All right. Jesus said, I come not to change the law, but to fulfill the law. One of the experts in the law answered him, Teacher, when you say these things, you insult us also. Jesus replied, and you experts in the law, woe to you, because you load people down with burdens they can hardly carry, and you yourselves will not lift one finger to help them. Why? Because when you go to the courtroom, you don't win the case based off any evidence. It's based off way of pleading out. All right? You don't get no trial by jury. Why? Because you get a bench hearing. All right? That's that's what's called actions of assumption, trespass. All right? They're saying that you committed and infringed upon and violated the contract that you agreed to. All right? Jesus replied, and you experts in the law, woe to you because you load people down with burdens they can hardly carry, and you yourselves will not lift one finger to help them. Woe to you because you built tombs for the prophets, and it was your ancestors who killed them. So you testify that you approve of what your ancestors did. They killed the prophets, and you built their tombs. Because of this, God in his wisdom said, I will send them prophets and apostles, some of whom they will kill, and others they will persecute. Therefore, this generation will be held responsible for the blood of all the prophets that has been shed since the beginning of the world, from the blood of Abel to the blood of Zechariah, who was killed before the altar and the sanctuary. Yes, I tell you, this generation will be held responsible for it all. Woe to you, experts in the law, because you have taken away the key to knowledge. You yourselves have not entered, and you have hindered those who were entering. Did you hear that? Did you hear that? You have taken away the keys of knowledge. You yourselves have not entered, and you have hindered those who have entered. Who was the one who closed that door? Thomas Jefferson, when he separated church from state. He closed that door. So it's going to take a Jefferson to open it. All right? If he was of the descent of the English people, then Thomas Jefferson would have not closed that door. All right? He would not have closed that door. So let's get into it. We talked about the Black church. We talked about the Southern Baptist church. We know that the Black church was a result of the Southern Baptist church, which was created by the Protestant church, which was created by Henry VIII back through the English Reformation of the Church of England. Not the English Church of England, because the English Church of England had this Reformation back in the time of King Edward the People, our Jesus Christ. All right? Through the English Benedictine Reformation, all right, as a result of what happened back in 597 through the Gregorian mission of the English Reformation, which still exists today by way of converting the Anglo-Saxons from their true understanding of who they was based off their time immemorial to now what we have now, a faith that's based off a belief, okay, a faith that's based off a belief in something that you don't know to be true. All right. So let's get to this. All right. Let's deal with this. Let's deal with where I want to go first. Let's do it. All right. Right here. Okay. This is case law. This case law, page 10. Everybody look. Crockett versus Sorensen. 568 F. Point Supplement 1422. Washington District, Virginia, Western District, Virginia, 1983. Please note these cases are prominent. Present cases that are very prominent in what the Third Tip English Church is trying to do for our English people. Okay? That was promised from time immemorial, even going back to the Bible. Okay? Even going back to the Bible. Let's prove it. Let's see what the justices has to say about it. Plaintiff brings this suit pursuant to Title 42 United States Code 1983 Declaration of Civil Rights, alleging that the course in the Bible instructions offered in the 4th and 5th grade of the Bristol Elementary School is in fact religious instructions and thus violate the Establishment and Free Clause of the First Amendment to the United States Constitution. Article 1, Section 16 of the Constitution of Virginia, the Virginia Code, and its sections plaintiffs request that defendant be permanently enjoined from continuing to teach the Bible course in the Bristol Public Schools, and the plaintiffs be awarded cost and attorney fee. The Bristol Association is another Protestant school, another Protestant church, all right? Just like the Southern Baptist Church and Convention. They're all Protestant, okay? They're all Protestant churches, and we know Thomas Jefferson had it separated through the Religious Freedom Act. Okay, church and state is separated, which is what the First Amendment protects: the right to religious freedom. All right, not just the right to religious freedom, but the right to that religious government of that religion. Majority of the religions that I have today don't have a government, because state and church was separated. Okay, so the religion that you practice or the faith or the belief has nothing to do with government. The state or the federal government cannot interfere. All right. Now, if your religious faith was a government or prior and you reestablished that government, the state cannot interfere or the federal government cannot interfere. All right. Because it's a violation of the First Amendment. Check it out. Let's go ahead. We're not going to go to the subject matter of the case. It's irrelevant. Right here. All right. Majority of how the Bible is interpreted, how religion is interpreted, is based off biblical illusions. Biblical illusions here in America. All right. Everything is based off, or how you interpret it is based off the symbols, terminology. All right. The mysticism of it. All right. No one looks at it from a concrete standpoint. That's your problem. Okay. That's your problem. Hold that thought. All right. Our language and popular culture are also replete with biblical illusions. The symbol of the American Medical Association, a staff with a serpent on it, is drawn from an episode in the Book of Numbers. When Moses, Book of Numbers. When Moses at God's suggestion raised a bronze serpent on a staff, and all the children of Israel who looked upon it were healed of snake bites. The phrase handwriting on the walls comes from a passage in the book of Daniel, in which handwritings on the walls foretold rough times ahead for Babylonian King Belshazzar. The popular phrases, the apple of my eye, is used in the Old Testament as one of God's descriptions for his people Israel. And of course, the term Armageddon is a site where the battle will take place, which will mark the end of the age as described in the book of Revelation. All right. Greetings, everyone. Greetings, Sister Jones, Countess Jones. Come on. Bear with me, y'all. I got a lot of screens open. All right, right here. All right, so Book of Numbers, when Moses, at God's suggestion, raised a bronze serpent on a staff, and all the children of Israel who looked upon it were healed of snake bites. The phrase handwriting on the wall comes from the passage in the book of Daniel, in which the handwriting on the wall foretold rough times ahead for Babylonian King Belshazzar. The popular phrase, the apple of my eye, is used in the Old Testament as one of God's descriptions for his people, Israel. And of course, the term Armageddon is the site where the battle will take place, which will mark the end of the age as described in the book of Revelation. These are all illusions, all right? They're symbolic, all right? They're metaphors. We must understand what's going on. But according to the English Anglo-Saxon verbiage, the English people, all right, it says here, Anglo-American law, as we know it today, is also heavily indebted to principles and concepts found in the Bible. William Blackstone, one of the most influential figures in the development of the common law, explained, the doctrine thus delivered we call the revealed or divine law, and they are to be found only in the Holy Scriptures. Upon these foundations, the law of nature and the law of revelation depend all human laws. That is to say, no human law should be suffered to contradict these. Did you hear that? This is what Blackstone's saying. The doctrine thus delivered we call the revealed or divine law, and they are to be found only in the Holy Scriptures. Upon these foundations, the law of the nature and the law of revelation depends all human laws. That is to say, no human law should be suffered to contradict these, i.e., the Anglo-American interpretation of the Bible and the origin of the Bible where it came from. Because King James didn't know a thing about the biblical scriptures of the Bible, how an Anglo-Saxon practiced it. He practiced that which was borrowed and carried on by the Church of England under the Roman Catholic Church by the way of the conversion of the Anglo-Saxon to the Gregorian mission back in 597. Do you know that, Brother Truth? No, you do not. All right. Blackstone also says that Blackstone posted that the laws of nature as well as the law of revelation was derived from God. Further biblical influences pervade many specific areas of the law. The Good Samaritan laws use a phrase lifted directly out of one of Jesus' parables, the concept of the fertile octogenarian applicable to the laws of wills and trusts. You hear that? is a large part derived from the book of Genesis, where we are told that Sarah, the wife of patriarch Abraham, gave birth to Isaac when she was past age. In addition, the Ten Commandments have had an immersible effect on Anglo-American legal development. So if you ain't taking understanding from the Anglo-American perspective based off how it was presented from the English people, and all that authority goes back to the crown. Okay? It goes back to the crown. All right? William Blackstone said all the judges who came up in this time were illiterate in Anglo-Saxon English law. They had to do the best they could in regards to the interpretation of that which was deposited by the old depositories of the law, i.e., the old sages. All right? Come on, y'all. You don't know what you're talking about, bro. All right? So we see Anglo-American. Very important, it said Anglo-American. So let's check that out. Common law. We only can be talking about common law. Let's be specific, right? Common law, Anglo-American, common law, one and the same. The common law is a system of principles and rules grounded in universal customs or natural law and developed, articulated, and applied by courts and the process designed for the resolution of individual controversies. In this general sense, the common law is the historic basis of all Anglo-American legal system. But why did Thomas Jefferson separate church from state if Anglo-American law was a part of the natural law, i.e. the organic law? Why? Why? It is also an important element in the origin and plan of the United States Constitution. Did y'all hear that? Did y'all hear that? Let's go down to the meat. The Anglo-American common law evolved from decisions of the three great English courts of the King's Bench, Common Pleas, and Exchequer Chancery, which were firmly established by the end of the 13th century. These courts, though created under the royal prerogatives, became effectively independent by virtue of their ancient origin and the prestige and life tenure of their judges. By that time, the American Revolution, two strands were apparent in the English common law. The private law was developed and acted between subjects, including complex doctrines of property, contract, and tort appropriated to a sophisticated landed and commercial society. All right, Brother Truth, you don't have a clue about what you're talking about. The public law product of actions in which the king was a litigant. You are no king. All right, consisted of the rules defining and limiting his role as peacekeeper, reflecting limiting his political and physical prerogatives, defining criminal conduct as a reflection of his role as a peacekeeper, i.e., the king's peace, and establishing a series of procedural rights according to the criminal accused. In a large and written English constitution, Parliament, as the supreme sovereign, had power to alter or abolish even the most fundamental common law rules. But by the convention, basic government institution, individuals' rights were ordinarily beyond the legislative change. Let's qualify that, should we? Right here. Becky versus New Jersey Highway Authority. Everybody pull that up. Becky versus New Jersey Highway Authority. This is from the New Jersey Supreme Court. 1953. All right? Everybody see that? Before that, let's go back to Villain versus Harris. All right? Let's go to Villain versus Harris first. This is the district court. Villain versus Harris, 1980 case. The state of New Jersey, whose boundaries coincide with those of the district, is one of the original 13 states of the Union. And is a common law state. The structure of the law may be looked to for the general background about prerogative writs in general and the writ of circulatory in particular. The New Jersey Constitution adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as the state. Article 22 of the Constitution continued the common law of England in force. That Constitution was replaced by the Constitution of 1844, modeled largely instructive of the content of the Constitution of the United States by Article 10, paragraph 1. It too continued in force the common law of England, as well as the existing courts of law and equity. So also is the current Constitution of 1947, Article 11, Section 1, Part 3 continued to enforce all existing laws of the common law of England. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's Bench, which the legislature was powerless to cut down or to assign to other courts. This principle is especially strong in those prerogative which we just mentioned. All right. Vested with it was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's Bench, which the legislature was powerless to cut down or to assign to other courts. That means the King's Bench should remain in New Jersey Supreme Court for forever. This principle was especially strong in those prerogative writs, of which the writ of circulator was most frequently sought. The complexities and the technicalities involving these prerogative writs that goes back to the time of our ancient forefathers, including the writ of circulator, induced the draftsmen, i.e., those judges, those legislators, and as well as those who execute those laws of the 1947 Constitution, erased the procedural necessities while preserving or presuming to preserve the judicial authority and the remedies. This was achieved by a single sentence, which is nothing more than the prerogative writs being changed or taken from the Supreme Court of New Jersey and now transferred to the Supreme Court of New Jersey. This was a violation of law. Why? Let's see what the Supreme Court has to say about this. All right. This was the district court said about the New Jersey Supreme Court of New Jersey, that the power of the King's Bench should not be altered from that legislative authority that was transferred to the Supreme Court of New Jersey, which they did in 1947. Okay? They did it because of the complexities and technicalities, because why? They were not the king. These prerogatives belong to the king. We must understand that. So let's see what the Supreme Court said. Betke, New Jersey Highway Authority. Okay? If you're a lawyer, then you should know this. All right? Jesus said that. You took away the keys and stopped those from entering to God's house. All right? To honor God's law. All right? Because every time you go into a courtroom, you got what? The Bible. The only thing missing with that Bible is God's laws. All right? God's law is church law, then the Bible can apply. Y'all have no clue. All right. Okay. We have here a proceeding under the, make sure y'all all see this. Bear with me, y'all. I'm having screen problems. Hold on. Y'all bear with me for a second. My screen shut down. All right. Come on, look this up. Give me 1 second. Statute 2A:16. Yes. All right, we're gonna talk about this, y'all. I do the research. This is what I do. All right, let's go back there. All right. We have here, everybody see that? We have here, this is opinion from the court delivered by Judge Henher. We have here a proceeding under the Declaratory Judgment Act. We know what a declaratory judgment, a final judgment, right? Act pursuant to New Jersey Statute 2A:1650 at sequence, all right? To determine the constitutional sufficiency of the section of law of 1952 purporting to authorize a liability of the state of New Jersey for guaranteeing punctual payment of the principal and interest accruing upon bonds not exceeding $285 million and the aggregate principal sum to be issued by the New Jersey Highway Authority, a body corporate in politics establishing the state of highway by Section 16 of the laws of the same year to provide inter alia for the construction and operation of modern express highways and no other highway projects as therein delineated, and in particular the consummation of the highway construction project to be known as the Garden State Parkway, extending in the general southerly direction from the southern point of Patterson, also as State Highway Route number 17 in Paramus or Ridgewood, as the authority may determine to by most feasible and practical to a point at or near the city of Cape May. All right. These deals with easements. All right. It was directed that for the purpose of complying with the provisions of the state constitution, the act authorized the creation of the state liability for the guaranteeing of bonds by submitting the people of the general election of 1952, blah, blah, blah. There was such submission and the act was approved. The Superior Court Judge Upward sitting sustained the Guarantee Act as not in contravention of state constitutional limitation about the use of the state credit, money, and taxing power. So all this deals with a corporation being created for the benefit of being able to take private property for public use, all right? And create under the statute authoritative law to be able to dictate how that body of politics, that corporation, to conduct itself. All right? Everybody needs to understand that. Let's move down. Let's start here. All right. Now, we talked about the power of the King's Bench. All right. We talked about the power of the King's Bench. All right. That the King's Bench is the Supreme Court of New Jersey. This is the case from Supreme Court of New Jersey. All right. This case is from the Supreme Court of New Jersey. Now we know the judges of the Supreme Court of New Jersey changed it up as a result of the technicalities and the complexities of the prerogative of the king. Because why? There is no king now, right? They took the king out of the equation. They took him out of the picture. All right. So check this out. I said it is urged. Make sure y'all see that. See this. It is urged that this is a peremptory command, all inclusive in its operation, interdicting the state's unconditional guarantee of the obligation of a corporation, either public or private. Significance is seen in the omission from this provision of the recently revised Constitution of the specific exceptions of public corporations to accomplish governmental purposes of which the particular type had then become commonplace. This incorporation of the limitation of the 1947 Constitution and the identical terms of the 1844 Constitution is deemed conclusive of a purpose to bar the extension of the state's credit directly or indirectly in every case. Amicus Curiae suggests that the Constitution itself makes what it terms the obvious distinction between a donation or appropriation on the one hand and a loan of a credit of a state on the other hand, by laying down in Article 7 of Section 2, Paragraph 3A qualified prohibitions of donation or appropriations by the state, but in Article 8, Section, let me read that again. Distinction between the donation or appropriation on one hand and a loan and the credit of the state on the other hand, by laying down in Article 8, Section 2, Paragraph 3, a qualified prohibition, all right? Really prohibition if it came from the king's bench, of donations and appropriations by the state. But in Article 8, Section 2, Paragraph 1, a unqualified prohibition of loans on the state's credit. It is also urged that there is difference of substance in the constitutional sense between the making of a loan or an incurring of an indebtedness on one hand and a loan or credit on the other. And the case at hand involves not a loan of money either by or to the state, but rather a loan on the credit of the state to an autonomous corporation entity. Did y'all hear that? Autonomous corporation entity. It is said that in the framers of the 1947 Constitution had in mind a modern exception permitting the loan of the state's credit to a state-created independent autonomous corporate entity known as an authority. The intention would have been expressed in terms also that the limitation was reenacted in the light of its previous judicial and legislative interpretation and application, and since the provisions of the 1844 Constitution had not been construed as permitted the loan of the state's credit to you hear that? The 1844 Constitution had not been construed as permitting the loan of the state's credit to a separate autonomous corporation, even for the public purpose. There is conclusive presumption that the framers of the 1947 Constitution and reenacting provisions without change did not intend that it should be construed differently. All right? At the time of the adoption of the 1947 Constitution, the limitations embodied in the 1844 Constitution had not been the subject of judicial scrutiny. Guess what? It now is. It has not been the subject of judicial scrutiny and assessment in relation to the public corporations of the class now before us, and the purpose to be served and the adoption of the limitation without phraseology change is without determining the significance. Listen, y'all. Come on. Listen, y'all. At the time of the adoption of the 1947 Constitution, the limitation embodied in the 1844 Constitution had not been the subject of judicial scrutiny and assessment. We just read Billings versus Harris that the legislature was powerless to separate the king's bench. And the 1776 Constitution, the 1844 Constitution, and the 1947 Constitution. That was the supreme law of the land, and the supreme law of the land was the common law of England. Now we see here in this case law under the United States Supreme Court in 1950. All right, this is in 1950. 1950, I think it's 1958. Let me just make sure. 1953. All right, this is after they changed it. So look what they did to y'all, English heirs and successors. Look what they did to you. This case is in 1953. They made the change in 1947. All right. And it was never questioned in 1947 about the change that was done in 1947 as a result of them undermining that which was in existence before 1947, and that was the common law of England, as Blackstone says. All right. At the time of the adoption of the 1947 Constitution, the limitation embodied in 1844 Constitution had not been the subject of judicial scrutiny and assessment in relation to a public corporation of the class now before us, and the purpose to be served in the adoption of the limitation without phraseology change is without determining significance. So we don't give a damn about what had took place. Now we're going to get to the rooty tooty. We seek for the reason in spirit of the provisions considered in the context of related limitations and provisions of the instrument embodying the organic law. What is essential quality in meaning which compared with kindred provisions operative in the same area of the governmental action? This is the question before y'all, and this is the question before the court. A state constitution, unlike the federal constitution, is not a grant, but a limitation of the legislative power. The state legislature exercise a portion of the sovereignty power residing in the people, subject to the limitation imposed by the federal constitution and its own organic law, and as well those so fundamental in the social compact and the Anglo-Saxon principles of natural justice as to be necessarily implied, and in the determination of the operative scope of such constitutional limitations. Courts are enjoined as in the construction of statutes and all other written instruments. Did y'all hear that? This is 1953. And all other written instruments to collect the sense and meaning of the clauses by the comparing of one part with the another, and by considering all the parts as a whole, and not one part as a separate and independent provision bearing no relation to the remainder. This is the primary rule of the exposition of the constitutional provisions. The thing sought is the intent of the people in imposing the particular restraint. Words and clauses are not to be isolated, but related to each other and to the whole of the instrument. If the real sense of the expression is to be had, the purpose of judicial interpretation is the discovery of the true sense of the form of words which are used. Taking all its parts into consideration, it is fairly possible, given them all the facts, whether the subject matter of such interpretive inquiry be an agreement between parties, a statute, or a constitution, the object is the thought which it expressed. Okay? The thought which it expressed. So let's get another qualification. Pulliam versus Alien. So all judges must follow the Anglo-Saxon compact. All right? We just read it for ourselves. I didn't make that up. Right here. 7. We're talking about the King's Bench. We know the King's Bench remained unchanged from 1776 to the present time. All right? Because we just seen in the case law that all provisions from time immemorial to the present time must be construed in the manner of the Anglo-Saxon compact. Let me just show that again before we go to this one. here. This is New Jersey Supreme Court of New Jersey, all right? Talking about the 1947 Constitution, and they changed it up. This case is from 1953, all right? And they're talking about it shouldn't change from what Bill versus Harris said about the King's Bench, all right? It should still be the same way in this present day and time. All right. A state constitution, unlike the federal constitution, is not a grant, but a limitation on the legislative power. The legislative power of the state of New Jersey is a limitation on what any branch of government can do. All right. And the legislative power said the King's Bench cannot separate from the New Jersey Supreme Court of New Jersey, but it did. The state legislature exercised a portion of the sovereign power residing in the people, subject to the limitations imposed by the federal constitution and its own organic law, and as well as those so fundamental to the social compact and the Anglo-Saxon principles of natural justice as to be necessary implied. So the principles of natural justice that should be applied, not just back then, but now it's based off the social compact of natural justice that existed from the Anglo-Saxon days, all right? Which encompasses the laws of the Bible based off Anglo-Saxon common law or Anglo-American common law, i.e. English common law. All right? We have to understand that. All right, let's get here. This is United States Supreme Court. We just heard what the New Jersey Supreme Court said about the common law of England and what was done by the hands of the judges after 1947. All right. Prior to 1947, all the constitutions of the states as well as the United States was based upon the common law of England. All right. And was headed by the King's Bench. But 1947, they became in conflict with the King's Bench. All right. Let's prove it. Everybody see this? Pulliam versus Allen. This is United States Supreme Court, 1984, May 14th. Where is this stuff coming from, y'all? Where is this stuff coming from? It's coming out of the woodworks now. It said right here, a number of courts challenged the King's Bench for the authority in those days. Among these were the Council, the Star Chamber, the Chancery, the Admiralty, and the Ecclesiastical Courts, in an effort to assert the supremacy of the common law courts. Lower court forbade the interference by the courts of equity with the matters properly tribal as the common law. Coke and his colleagues of the Star Chamber had declared the judges of the King's Bench immune from prosecution and competing courts for the Judicial Act, but not judges of the Star Chamber. All right? Judges of the King's Bench were immune. Judges of the Star Chamber were not. Let's prove it. All right? In doing so, they announced the theory upon which the concept of judicial immunity was built. The judges involved in Floyd and Barker was a common law judge of Versailles who had presided over a murder trial. He was then charged in the Star Chamber with conspiracy. The court, for itself, concluded that the judges of the common law should not be called on account before any of the judges at a suit of the king. All right? Check this out, y'all. And it was agreed that in so much as the judges of this realm, all right, 1980, this is from the United States Supreme Court, all right? It was agreed in so much as the judges of this realm that an administration of a justice under the king to all his subjects, they are not to be drawn into question for any supposed corruption which extends to the annihilating of a record or of any judicial proceeding before them, or attending to the slander of the justice of the king, which will trench the scandal of the king himself, except it be before the king himself. The king himself. For they are not to make any account, they are only to make an account to God and to king, and not answer to any suggestion in the Star Chamber. Okay, so that tells you right now, United States court recognized the king, even though the king ain't there as a result of y'all ignorance. He still recognized the position of the king. Only you will only recognize the king when the king returned based off his prerogative, which they have preserved for themselves through statute, but it's not their right because by way it was given by statute, by way it can be taken away by statute. Because the power is in the people. The people can be revived by a king because it's based upon what we call body of politics. King, body politic, corporate, or person. Okay, that means a corporation soul. It takes if your members of Congress created the body politics and created laws for corporations, then guess what? You are those corporations. Let's move forward. Let's get some more qualification. All right, based off the king. Now let's hear directly from our King, Jesus Christ, our Lord, the one who's speaking in Luke. What was it? Luke 11:45 through 57. All right. This is King Edgar the Peaceful, our Jesus Christ from the Third Temple English Church of England, reincarnated in me in this present day by personification through incorporation of the laws of King Edgar the Peaceful, who is our Jesus Christ. All right. You're going to hear it right now in case law of him giving instructions about those judges that were a part of his bench. All right. You're going to hear from him a 1950 case. It's all involving First Amendment rights. The Supreme Court of Alabama. So this is the Fifth Circuit District Court. All right. Will McRaney and Southern Baptist Church of America. All right. This is where all those members of the church, i.e., black people, you are part of this branch of church because it's subject to the Protestant teachings. All right. We know the Protestants were the ones who were created by the church who broke away from Rome. Okay. It had nothing to do with the English people. The Church of England has nothing to do with the English Church of England. All right. Nor the people of the Roman Catholic Church has anything to do with the English Church of England. You must understand that. All right. So we already got the instructions from Billen versus Harris, as well as we got it from Pole versus Oleum in regards to the judge is supposed to follow the authority of the king. All right. All kings, for that matter. All right. But the real and true and prominent king was no other than King Edgar the Peaceful, because he was the only king in his reigning, in his days of reign, that was peaceful. Okay. The word Jefferson means peaceful. All right. If Godfrey the Fifth got a band Jew, son of Folk, father was Folk the Fifth, ruler of Jerusalem, and we know Jerusalem means city of the peace. That means that they were all family. All right. They were all family. Let's get there. We already read this case in my last lecture, so we're not going to do that. I'm just going to go to the court's opinion. Andrew S. Ullman, Circuit Judge Smith Williott, Duncan and Wilson, circuit judges, dissent from the denial of a hearing en banc in regards to what we call uh, uh, a First Amendment protected right in regards to what was this bill dealing with? Somebody being terminated as a result of his position in the Southern Baptist Church. All right, but as a result of separation church to state, the federal government cannot intervene as regards to who the church hire, the church doctrine, etc. All right, whether the church want to be an abstract government believing in spooks, or do want to be a government function church that's governed by governmental law. Okay, such as the laws governed by the king and parliament. That's what we chose. All right, a religious government, i.e., a body of politics. We must understand that. So this is the ruling on that body of politics. All right, let's just go back up here. That's 19. First Amendment right, y'all. The First Amendment forbids government intrusion in matters of church government. Did you hear that, y'all? The First Amendment forbids government intrusion in matters of church government. So the first question each and every one of y'all should ask yourself, well, I got two choices. Either I can be in the government that I'm subject to now or the church government. But your church government that you're associated with is not a government. It's just a building that you go there to worship based off of faith with no protection from government because state was separated from the church. So what protection do you got from God? Because there's a Bible in that courtroom. So that means that people of God got protection in that courtroom. It's just what people in that courtroom. Because the case law we just read in regards to the origin of the Bible comes from Anglo-American origin. All right. Not the abstract, but the concrete. All right. From Anglo-American law, which is Anglo-Saxon law, which is English common law. All right. You can't have English common law if you're not an English person. If you are using English common law, you're not an English person, then you're no different than anybody else who's came to be English. I'm going to prove it to you. All right? Check it out. Check out where I'm going with this. The First Amendment forbids government intrusion in matters of church government. It secures church autonomy with respect to internal management decisions that are central to the institution, central mission. And a component of this autonomy is selection of individuals who play certain key roles, such as I, your king. So I can care less about how you feel about me being a king because you have no authority to change my position as being king based upon the First Amendment because no religious test is required. So how many of y'all have done that from a legal standpoint? Because a lot of y'all call yourself kings. All right? A lot of y'all call yourself kings. The case falls right in the heartland of the church autonomy doctrine. A former Southern Baptist minister brought the suit to protect his dismissal from a church leadership. We're not going to go through that again. You can go through it on your own time. Let's just go through the decision as given by the judges. Now, this is instructions to the Fifth Circuit Court from the Supreme Court, which just told you in Pulliam versus Eliam that all judges must follow the laws of the of King. So follow the laws of the what it says. Follow the laws of the king. All right. Follow the laws of the king. Supreme Court has told us that the judicial power of the United States does not extend to ministerial disputes. That means a church government. The church head government is exempt from Supreme Court judicial powers that was created by the government outside of the separation of government, which was a part of the unification of government under the federal government of the crown. All right? Let's get to the meat that I want y'all to see right here. As always, I start with the Constitution's original public meaning. The ecclesiastical autonomy doctrine has a rich historical pedigree, and that the history informed the meaning of the Constitution and its religion clauses at the founding. Okay, we must understand that very, very important, as they stated in that case. All right, in regards to the Anglo-American connection of the Anglo-Saxon law to the Bible itself, and doing away with the so-called illusions that are perceived by way of your lack of understanding of English law. In the Middle Ages, clergy were categorically exempt from reach of the civil courts. The constitutional history and constitution of the Church of England, 384-94, London, 1895. Okay? Now they talk about the Church of England, and the Church of England was separated by Thomas Jefferson a letter submitted to the Virginia Congress. All right? So this is what they're talking about. During the reign of, so this is what they separated you from, y'all. Okay? When there was a fusion of power, when all the judges obeyed the king, they obeyed the Lord. The Lord was the true Lord, King Edgar the Peaceful. During the reign of the Saxon king, civil courts had no jurisdiction over clergy accused of even clearly secular crimes unless and until the bishops divested them of their spiritual authority. Okay? Edward and Guthrum, if they stated in Edwin and Guthrum in their chronicles, it stated if a priest commits a crime worthy of death, this is a criminal crime, all right? He should be seized and kept until the bishop's judgment. And during the reign of our Jesus Christ, which is King Edgar the Peaceful, this is which was this case? 2020, y'all. 2020. 2020 case. I've been looking up this case since 2020, and I haven't found it. All of a sudden it pops up. It said, if a priest commit a crime, make sure y'all see this. If a priest commit a crime worthy of death, he shall, worthy of death, he shall be seized and kept until the bishop's judgment. And during the reign of King Edgar the Peaceful, our Jesus Christ, 959 to 975, the church required all disputes between clergymen to be addressed before bishops and not circular courts. All right? Not circular courts, because circular courts are what you have now. All right? Before that, the fusion of government had spiritual courts. Spiritual supervisors retained exclusive competence to discipline clergy, and civil courts could not intervene in church matters. First Amendment. All right? But you're missing the government within that First Amendment. So he still gave you the ability to be able to be protected by the First Amendment under your religious doctrine. But what's missing from your doctrine is the government. Church exclusive jurisdiction over clergy serve as a one-way jurisdictional boundary. Although civil courts were powerless to interfere with the matters affecting clergy or other ministerial prerogatives, religious authority extended their power into operation of civil courts in a variety of ways. For example, ecclesiastical leaders serve alongside a high civil official on civil courts. King Edgar mandated that the bishops of the shire, i.e. the county, and the aldermen sit, the aldermen, those learned ones, together as a civil judicial body, i.e. body of politics, empowered to imply both the law of God and in the secular law. All right? Edward Edgar, from one of his implemented laws, stated thus, while civil officials had no role in ecclesiastical matter, ecclesiastical officials adjudicated both sectarian and secular matters. Did you hear that? So these are laws going back to the days of our Jesus Christ, King Edgar the Peaceful, through what we call the English Town Reform. Okay? Let's qualify it. Everybody go there. The English Benedictine Reform or Modernistic Reform of the English Church, not the Church of England. In the late 10th century was religious and intellectual movement in the later Anglo-Saxon period. All right, it's talking about the Anglo-Saxon Compact we read in the case law, right? That's what we read. It said the English movement became dominant, all right, under King Edgar. King Edgar is King Edgar the Peaceful, 959 to 975. Let's go back to the case law. There you see it, y'all. So this is not no joke right here. This is the actual truth. All right? It's right there. Look what he did way back in 975. It said the English movement became dominant under King Edgar 959 to 975, who supported the expulsion of secular clergy from monasteries and cathedral chapters and their replacement by monks. The reformer had close relations with the crown, furthering the interest and dependent on its support. The crown is what's being repped now. Let's go here. Right here. Marshall versus New York. At common law, the crown of Great Britain, by virtue of its prerogative, had priority over all subjects for the payment out of the debtor's property of all debt due to it, whether the property was in possession of the debtor or a third person of custodial legis, i.e., custody of the law, and the priority could be defeated only be postponed by way of a lien before the king or the crown or the corporation shell was able to exercise his sovereign prerogative. All right? His sovereign prerogative. They separated the prerogatives of the king. All right? So how can he enforce it if they separated? All right? They separated the prerogatives or priorities of the king for some administrative. Right? Look, a like right, a priority is right here. A like right priority based on the sovereign prerogative belongs to the state of New York as a higher court has decided through her adoption by her constitution of the common law and constituted a debt due to the state by a sister state corporation as a license fee or tax for a privilege or doing business in New York. Although no statute of the state makes the tax lien or delay its priority. The question whether this priority is a prerogative rule, right, or a rule administrative is the question of local law. The determination which by the highest court of the states conclude is the federal. The priority extends to all property of a debtor within the borders of a state, whether the debtor be a resident or a non-resident. It is enforceable against such property in the hands of a receiver appointed by the federal court within the state, such as the receiver takes property subject to all liens, priorities, and privileges existing or accruing under that state law. Okay? You must understand what's going on. Why do I say that? Let's see. Back to this case. Supreme Court, New Jersey, Beckney versus New Jersey Highway Authority. This case involved the authority for the state to be able to give a life to a corporation by way of an enacted statute under New Jersey statute annotated 2A 1650 at sequence. All right. This is what they're trying to do. So let's review that statute, y'all. This is what you should be doing in your own state. All right. Because this is how they're taking up all the room inside the local communities by letting you by the property falling into foreclosure or the community fall into demise as a result of we're not being funded or being put on the equal funding for us to be able to have these things. That's the why we're we are at imbalance in regards to due process of law as a result of what I'm showing you now. All right? Because you are persons. New Jersey Statute 2A 1650. All right? Y'all see it right here. In lieu of what we call a declaratory judgment. All right? Very important. Let's look at the statute. Everybody see that? New Jersey Revised Statute, Title 2A, Administrative and Civil Criminal Justice, Section 2A 1650, persons defined. As used in this article, persons includes any person, partnership, joint stock company, unincorporated, association, or society, or municipal, or other corporation of any character. Did y'all hear that? Did y'all hear that? So if you understand they're talking about corporation and the authority that the state had the right to create the corporation, then the state is the corporation itself. How can a corporation create a corporation? We know that the corporation must have a charter. We just read that New Jersey's charter is not a grant, it's a limitations instrument of limitations. All right? It must go based off the original compact of Anglo-Saxon origin. All right? We must understand that. And 50. Let's see declaratory judgment. So it's 1650 for the definition of person, which means corporations are persons, right? You got it right there. Right? Concerning the declaratory judgment. All right. So then you got persons, 2A 1650, and declaratory judgment is right down here. Declaratory judgment forms and effects. All right. Right there dealing with criminal civil procedures. All right. So this ain't like I'm making this up. All right. In regards to Article 8, Section 3, and Section 1 of New Jersey's Constitution in regards to taxes. We just said that all debts, and we know taxes is a debt, is in the crown. All right. The only way the crown can be usurped from his position of priority or prerogative and collecting that debt is that by way of a lien put on you before the king was able to enforce his prerogative. All right. This is what we're talking about. Those liens. All right. We're talking about those liens. What liens? Let's see. Let's do chapter 8. (1947) Constitution. Ain't this what we're talking about? Article 8. Taxation and finances. Right there. Taxation and finances. All right? That's not the common law of England, because the common law of England is just said in case law that the crown gets paid first. All right? The crown gets paid first. We know the King's Bench said in Villain versus Harris, it was long ago, the former Supreme Court established by the Constitution 1844 vested all the power with the king's bench. The king's bench represents the king. And we know the king represents the crown. Okay? We have it here as well. Where is it at? Oh, I got too much to cover, so we're gonna move forward. All right. So we see it right here in New Jersey statute. All right. Article 8. All right. Which is qualified in the statute. This is what they use to tax. All right. This is what they use to tax. Now let's go back down here and see the compact that they wrote. Right here. Somebody been lying to y'all. A state constitution, unlike the federal constitution, is not a grant, but a limitation of the legislative power. We know Billy versus Harris said that the legislative power confined the king's bench with the king's prerogative. But now the state has incorporated their own priorities and prerogatives, which is only by way of statute. But the crown has full priority because we just read it in case law. The state legislature exercised a portion of the sovereign power residing in the people. So how did they get this sovereign power? Because they took the people out of the equation by making the people corporations. Subject to the limitation imposed by the federal constitution, the federal constitution allowed them to make you corporations. All right, by way of the Naturalization Act by now 1940, 19 was it? Naturalization Act of 1790. Okay, that's how they did it. That's not the organic law. That's not the organic law. The grant that was given to the federal government states that the federal constitution and its own organic law, and as well as those so fundamental in the social compact and the Anglo-Saxon principles of natural justice as to be necessary implied. Okay? That's what should be implied in a court of law, not what they want to imply in a court of law. We must understand that. All right? So just look at, we understand that we English people, Frederick Douglass said we were English people, as I come to my closing, right? Let's just understand this, all right? I talked about this already. I just got to continue until y'all get it right. In his book, From Freedom, From Bondage to Freedom, y'all, he said, I'm quite willing and even happy to attribute any love of letters I possess and for which I have got, despite our prejudices, only too much credit, not to my admitted Anglo-Saxon fraternity, but to the native geniuses of my sable, unprotected and uncultivated mothers, a woman who belonged to a race whose mental endowment is at present fashionable to hold a disparagement and contempt. Okay? Who is he talking to? They're talking to these black people. All right? Let's look at black people, African Americans. Shout out to Brother Milligan from the House of Milligan. We was talking one day and he brought this to light, which I never really thought about it till now, till he brought it up. African Americans. We know African Americans or black people are the ones inside these churches, all right? Whether you're inside the church, whether you're outside the church, you're still practicing belief, all right? You believe in some God based off some type of perception because the Bible got them all in there. You're Egyptian, you're Israelites, all those are mentioned in that Bible, all right? So the Bible covered all of them, all right? Which one you want to be is the question I'm asking you, all right? Because we know those African Americans, i.e. Anglo-Americans, were indentured servitude based off those teachings that were taught in the black church. And that teaching was taught in the black church where the was the teachings of the Church of England that go all the way back to 597 when Christianity was brought to convert the Anglo-Saxon, i.e., those of Albion. All right, all right. The Isles of what they call Britannia or the British Isles, whatever name you choose to call them. These were Anglo-Saxon Berbers. All right. Berber is an English name. Yes, it is. Look it up. Family Crest Coastal Farm. All right. So these people now identify as African American, also misnominated Negroes, blacks, etc. All right. It's in 2020, 46,936,733 in the percentage. All right. All right. Predominantly Protestant, historically black Protestant, evangelical, mainland Protestant, Catholic, Jehovah, Muslim, all y'all up in there. All right. 46,000. All right. You see it. Look at that number, y'all. 46 million. That's how many of us they assume is on in the United States. All right. In the United States. This is your religion. We ain't talking about the government. We talking about their presumption on the faith you practice. Why? Because they gave it to you. And we know that the Protestant faith is how they kept the indentured servitude because to them, that was their heaven. All right? Let's just qualify it. I better show everybody that you know. Everybody see that? Classification, Protestant. Orientation, Baptist. Theology is to evangelize, to spread. All right? Everybody listen. The Southern Baptist Convention, alternatively the Great Commission Baptist, is a Christian denomination based in the United States. It is the world's largest Baptist denomination, a large Protestant and second large Christian denomination in the United States. In 1845, Southern Baptists separated from the Trinity Convention in order to support, this is 1845, to support slavery, which the Southern Church regarded as an institution of heaven. All right? There's your sources. There's your sources, y'all. Founders of the new organization claimed that according to the Bible, slavery was an institution of heaven. All right? We know that's a lie because we just read in case law. The Bible and laws dealing with the government goes back to Anglo-Saxon time. All right? So they switched your understanding about the authority of heaven, all right, which was in the Anglo-Saxon time because their heaven didn't start till what? 1845. All right? Dred Scott said that they was in hell prior to 1845. Dred Scott said that. Case said that. All right? So we must understand that if this is their heaven from then till now, then that means that you are in hell. That means that you are in the star chamber. All right? The Jews were the ones who spelled by the Plantagenet king, and the Jews are the ones who was the exodus from the king, right? Because we understand that that story was an illusion, as the case law said, right? An illusion. Let's go back to where we were. African American. So keep holding on to this term. Because if you're not in the English Third Temple Church, I'm assuming that's what you want to be. All right? So they'll come, when the door is open, it's going to be us coming out. It ain't going to be you coming in. All right? It's going to be us coming out of the temple, not coming in the temple, because you already made your choice. All right? You already made your choice of who you want to be. All right? The book is open. You got the English name, you got the English languages, all right, from all over the continent, but you still want to be Protestants, all right? You want to protest against your English inheritance. Yes, that's what you want to do. Because it said all African Americans' faith comes from that Bible, all right? And when I say the Bible, I'm not defaming the Bible how it should be interpreted from a concrete standpoint, because God's law is immortal, going back to the time when that etheric person or etheric deity who came to manifest us in His creation. Because whatever the mind, the body can't live without the mind. All right, all animals got a mind. All right, but my mind is not the mind of an animal. My mind is the mind of a lord. We know in the Black Law Dictionary, lordship and man is defined totally different. In contract law, a man was a vessel, was a vessel, a tenant, a fiduciary. All right, a lordship was a proprietorship who had an interest in some type of estate. So if you have an interest in the state, then you must come to the Lord, because the Lord is associated with the House of Lords, and the House of Lords is established with the head of the government, i.e., king and parliament. All right? See, brother Truth, how much you lack and what you say you have? Okay. Black people, Negroes, African Americans, also known as Afro Americans or Black Americans, are an ethnic group, ethnicity. So the Black or African or Negro is not a part of an ethnicity. It's not, because you must get into genealogy or nationality. Nationality. All right? But that's not the case dealing with the classification of an ethnicity here in America. Because it's why they say African America. African is a landmass. All right? Africa is a landmass. So the people in Africa call themselves African. America is assumed to be the name of this landmass, so they call themselves America. But America and the land had nothing to do with a nation of people, because they define that by the color of their skin. And that color of skin was white people. All right? We must understand that. So we know that white people are not African or Black American, which are an extra group consists of Americans here, with partial or total ancestry from any of the Black racial groups of Africa or any other part of the continent, what we call Europe. African Americans constitute the third largest racial ethnic group in the United States after white Americans and Hispanic Latino Americans. The term African American generally denotes descendants of African enslaved in the United States. So they're telling you right there. Okay? And what is the percentage again? 46,936,733 in 2020. All right? Yes, in 2020, 46 million African Americans are still slaves because of your protected rights that come from government has been separated because of your faith and your religion and something that you know nothing of. All right? It's a fact. Let's prove. So if the 46% of population of us are misnomer as African Americans or Black people, we know they said Black people were the ones who saved in North America. All right, let's see how many English people in America. All right, let's see. Because English is not a color. Can anybody agree? English is not a color. Look at that number right there. In 2020, look at that number. Y'all look at that number. 46.5 million people in 2020. The same amount as Black African Americans. 46,936 people. That's because we know we've been having children, all right? So the number has gone up, all right? But there's 46.5 million English people that don't exist on the planet, and there's 46.9 million people called Black people that exist on the planet, all right? How many people are white people? White Americans. There's 235 million of white people identified by the term white people here in North America. 235 million, okay? We know that the African American and English people are damn near the same, but there are no English people here because English people are supposed to have been extinct. But yet we got the English name, right? We got these names, we all speak English, right? So who actually fits the description of the English people, all right? Because we know under the Naturalization Act of 1790, they had nothing to deal with an ethnicity that refers to that of English. They chose the word white, specifically white. So let's go back to the case law. And Ray versus Hassan. In closing, to summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person within the meaning of the statute, as interpreted by the Supreme Court, it is necessary to determine first a particular group or racial subdivision to which an individual belongs. In practical effects, proof of this fact is a matter of genealogy. An individual who presents an aberration from the color of skin, such as those calling themselves African or Black, or those who call themselves white, does not classify or fit the criteria for a genealogy test. All right? Not at all. All right? English does, though. All right? We know English is, let's just go there. Right here. The English people are an ethnic group and nation native to England who speak the English language, soon to be a West Germanic language, and share common ancestors to history and culture. The English identity began with the Anglo-Saxon, which they were known as Angelicians, meaning race or tribe of Angles. Their ethnonym is derived from Angles, one of the presumed to be Germanic people who migrated to Britain around the 5th century. No, Germanic people migrating to Britain, but they were not those Britons. Those people who migrated to Britain were those ones who converted those Anglo-Saxons to Christianity. All right? That's a fact. That is a fact. We are the true English Anglo-Saxon Berbers. All right? Let's prove it in my closing. Let's go to the real first. Villain versus Harris. Did I have it here? Oh, I'm sorry. I already had it. Villain versus Harris. And Ray versus Hassan. I'm sorry. And Ray versus Hassan. I didn't see one case law that you brought up, Brother Truth. All right? Since you that skilled in law. All right? I ain't hear one case law you presented. So since we know that 46 million people in the United States identified as English people or Black people are could be considered to be the same people, because the white people themselves never called themselves Anglo-Saxons. All right, the courts never classified them as Anglo-Saxons. All right, very important to understand that. Then there was a group called WASP, White Anglo-Saxon Protestant, going back to Protestant. All right, which is the majority of the practice that Black people practice, absent from ethnic nation or a government that's able to protect that religion that you practice. All right. So someone has to approach which must be followed in deciding whether you, my brothers and sisters, are a particular person applying for citizenship is a white person, because if you're Black, you still consider white, because they allowed you to be a citizen under the 14th Amendment, still subject to the subjectivity of the white person. All right? Because they ain't gonna never put you in the state of heaven like they are in. Hold that position. If their intermediate heaven is that status as a white person, all right, because Southern Black Convention was those Black people who were Protestants, which were excluding those Black people who were or took on the practice of Protestant as a result of it being done by way of what we call undue influence, which is by way of a psychological control over the mind, which puts us in the form of duress, because that's all we got. All right? That's what all Frederick Douglass had until he woke the hell up. Okay? You know what I'm saying? So just like Martin Lawrence said, we better go on that freedom train. All right? That train. All right? So it says here, to summarize the approach, which must be follow in deciding whether a particular person, that means you, applying for citizenship is a white person within the meaning on the statute, because we see the population of white people is 235 million over here. And if you want to be included in that group, then you better go change your color of skin. All right? Because your skin don't look like them. You as a black person, the only rights you got in lieu of those rights that white people have is what's given through the 14th Amendment. Okay? All right? Yeah, but you still got the English name. They don't want it. They want to be white people. You want to be black people because they want to be black people, but you don't have to be black people. You can be English people. Why? This is what the case said. To summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person, which means meaning of the statute as interpreted by the Supreme Court, it is necessary to determine first a particular group or racial subdivision to which the individual belongs. In practical effect, proof of this fact is a matter of genealogy. You want to take that test, or do you want to take the color test? That's the practice. That's the choice. Most of y'all took the color test. You don't really want to deal with no factor of genealogy because they don't take the blood test and ain't gonna do it. It's your surname. All right. Proof of this fact is a matter of genealogy. An individual who presents a aberration from the color of a skin of the group of which he is a member, such as light-skinned Chinese or Japanese, or a dark-skinned Anglo-Saxon. It was subjective in the suggestion of what they presented as an example as an Anglo-Saxon. All right. Frederick Douglass called himself an Anglo-Saxon. All right. His paternal origin of ancestry was Anglo-Saxon. He could have said black, Negro, colored, Ethiopian. He didn't say that. He said Anglo-Saxon. So, of course, when an individual applying for system has a skin of a different color than it's usual for the members of the group from which he claims to come, a strong burden of proof then rests upon him, Brother Truth, to show by the use methods and proving in genealogy that you are, in fact, a member of this group we call English Anglo-Saxon Berbers. After the individual IU has been traced into this group, the second question which the court must answer and which you must answer is whether the member of the group as a whole or white person, as Congress understood the term in 1790 when it was first enacted by the statute, because you're not a part of the English Church of England. We don't know who you are, but yet you claim to be a part of the English church or the English people. How can you be part of the English people and there's no government set up for you? I don't see a government established by you. I'm the king of the government. All right. I incorporated, personified, personified, or and what's it called? Personify, incorporated, and what's the other one? Personify, incorporated, personified, incorporated, personified. I forgot the term. Identified. It'll come to my mind. All right. As King Edgar the Peaceful. All right. Because there's no religious test required. So if there was no religious test required for the position of a leader of the English people under the Easy Common Law, why didn't you choose that position? Okay. Why didn't you choose that position? All right. And deciding this latter question based upon the 1790 Naturalization Act, which had nothing to do with a nation, nationality, genealogy, ethnicity. All right. It says deciding upon the question will be classified by ethnologists who will have made a study of racial origin, but rather what the group of the people then living in 1790 was characteristics then existing were intended by Congress to be classified as white person. Applying this principle, the court finds the petitioner is an Arab and that Arabs are not white person within the meaning of the act. So Arab is a nation, nationality, a country, Arabia. All right. So you claim to be an Englishman. All right. You're not an Englishman. Right. You didn't even use an English name when you identify yourself to the people. Why? Because there's a reason for you not identifying yourself. Because when they get in trouble, just like Jesus said in Luke, you ain't going to be nowhere around. Nowhere around. All right. And in closing, the decision of Supreme Court United States versus Bongard Singh thing dealt with the same thing. So let's get this case out in closing. It all is dealing with the citizenship here in North America in regards to the interpretation of 1790 Naturalization Act. But look what they say. It is not without significance in the connection that Congress, the Act February 5th, 1970, has now excluded from admission into this country all natives of Asia within designated limits of latitude and longitude, including the whole of India. You get into longitude, latitude, ley lines, you get into dragon lines. That's where the word dragon comes from. All right. My Archbishop is going to do a lesson on that one day, hopefully when you get time. This not only constitutes conclusive evidence of the congressional attitude of the opposition to Asiatic immigration generally, but it's persuasive of a similar attitude toward Asiatic nationalization as well, since it is not likely that Congress would be willing to accept as citizens a class of person who is rejected as an immigrant. But now these immigrants are allowed to become here. Why? Because it's modern day slavery. All right? It's modern day slavery. That's why they want them to come here, because they know they can't enslave you no longer. All right? Article 4, Section 3. All right? And that's why they can tax them. All right. It follows that the negative answer must be given to the first question, which disposes of the case and renders the answer to the second question unnecessary, and it will be so certified that the ill-chosen name Caucasian, invented by that guy Blumenbach, is an illusion. There go that word again. To a South Caucasian skull, a special typical proper proportion, and applied by him to the so-called white race. It is still carried, it breeds into one race people such as Arabs and Swedes, i.e. Netherlands, Neanderthal, Northmen, Frankish. Although these are scarcely less different than the Americans and Malays, who are set down as two distinct races. Again, two of the best marked varieties of mankind are the Australians and the Bushmen, neither of whom, however, seem to have a natural place in Blumenbach's theory. Why? Because he wasn't concerned about them. Who was he concerned about? Let's see. Keynes himself says that the Caucasian division of the human family is, in point of fact, the most debatable field in the whole range of anthropological studies. Did you hear that? So they're not sure where they come from. All right. Hence, it seems to require a strong mental effort to sweep into a single category, however elastic, so many different people face off a color of skin. Europeans, North Africans, West Asiatics, Iranians, and others all the way to the Indian Gandic plains and uplands, whose complexion presents every shade of color except yellow, from white to the deepest brown to even black. All right? To even black. But they are grouped together into a single division because their essential properties are one. All right? Their substantial uniformity speaks to the eyes that see below the surface. We recognize a common racial stamp in the facial expression, the structure of the hair, partly also the bodily proportion. In all of which points they agree more with each other than with other main divisions. Even in the case of certain blacks of very dark races, such as the Beja, Somali, and a few of other Eastern Hamanic, we are reminded, meaning the court are reminded instinctively of more European or Berbers. So that means that they gave two examples, European or Berbers. If you're talking about Berbers, which is what we classify as Anglo-Saxon Berbers, and you're dealing with Europeans, and European is a de facto description of people living on the European continent. All right, then they're reminded more of Berbers than Negroes, i.e. African or blacks, think to a more regular features and brighter expression. All right? So there you see it, brothers and sisters. There you have it. I have returned. All right? I'm removing all the confusion that the confused people are confusing you with. All right? I'm removing all things. Let me make sure I didn't miss nothing. No, I just want to give honor again to my man Frederick Douglass. My man Frederick Douglass. This man was the first recorder of deeds. So he knew where the property belongs to. He just couldn't say nothing. All right? This man was the first recorders of deeds. He understood the women's suffrage. He understood that. All right? He understands that the want for our people. He couldn't convince these people over here. He had to go over to where he was the most recognized based off his theories. All right? Which became a fact. All right? Because he brought that belief from his faith to fruition. All right? And he became free. All right? Those who enslaved him freed him. Okay? We must understand what's going on. Y'all see this? Let's just go here. Douglas' mother, enslaved African. So she was Anglo-Saxon, y'all. She was English. All right? She was English. Let's find recordings of deeds. As a child, Douglas was exposed to a number of religious sermons. In his youth, he sometimes heard Sophia Auld reading the Bible. In time, he became interested in the literacy. He began reading and copied Bible verses and eventually converted to Christianity and described this approach in his last biography. Let's read this before I close out. I was, well, I'm gonna read this. No, I'm not going to do that. I just want to go to his position in as the court of deeds. Douglas family. He definitely was a kingmaker. Douglas family is a prominent American family originating from Godova, Maryland, United States, and was founded by the politician activist Frederick Douglass. All right. His family would later go on to become a part of African Americans' upper class, continuing to provide leadership and intermarrying with descendants of the African American educationalists and political kingmaker. What's that? A kingmaker is a person or group that has great influence on a role or political succession without themselves being a viable candidate. Kingmaker make use political, monetary, religious, or military means to influence the succession. Originally, the term applied to activities of Richard Neville, 16th Earl of Warwick, during the War of the Roses. Example, these are all examples, all your illusions. But the concrete story was the War of the Roses because the Plantagenets lost their authority at the Battle of Battle of Bosworth. All right? You don't want to know what that is? You can go to my last lesson and then I will explain that to you. But like I said, let me just go here. Back here. Quarter of these. Let me just type it. In closing, the recorder of deeds or deed registration is a government office tasked with maintaining public records and documents, especially records relating to real estate ownership that provides person other than the owner of a property with real rights over that property. So, brother Truth, you don't understand what's going on because if you're dealing with trust, if you're from your perspective, is not dealing with any type of real estate. All right, you're dealing with false estates. All right, and that's what you're doing. You're giving our estate away to somebody else. How are you gonna give something that you don't possess? All right, so stop it, brother, or else I'm coming for you. All right. So on behalf of all my brothers and sisters of the English, Anglo-Saxon, Berber ancestry, uh, understand that our time is near. Okay, our time is definitely near. All these cases are right now are before a court of law. Okay, and all judges based off pulling and basis alien have to obey the king. All right, they have to obey the king. This was instructed by the United States Supreme Court, which understand that the authority of the United States Supreme Court does not differ from the authority of the King's Bench, which is New Jersey Supreme Court, as instructed in Bill versus Harris. So with that, we at the Third to English Church of England, on behalf of my Queen, Sister Galveston, from the House of Galveston, as well as my Archbishop, as well as all those moderators who are there, as well as all those who want to be here, and all those who will be coming shortly to the Third to English Church. I love you, and I'll see you in your coming. With that, I say peace.